Okay, we're going to talk about writings, recordings, and photographs. Okay, admissibility of writing, recording, and photograph. These are literally what I just said, but they're not objects. Writings, recordings, and photographs. Pictures, that's what we're looking for. The admissibility of these things, but not actual objects. Generally, for that piece of paper, for that document, for that picture, what do we want? What is considered the best evidence? We want the original. And under the thing called the best evidence rule, what is generally considered the best evidence? The original. That is correct. So generally, when we're looking at a best evidence rule question, we start step one with the premise that if it applies to one of these things, the writing, the recording, the picture, we want the original, of course. But that would be too easy. So generally, do we have the original now in the case at trial? No, we don't. If the item is just lost, despite our best efforts, we can't find it, we don't know where it is, it's gone. The issue then is, can we use a copy? Yes, you may use a copy under the best evidence rule. You can still use the copy of that thing, of that document, if what? If it is authenticated. If it is authenticated. And for purposes of the best evidence rule, authentication means there's no evidence of tampering. No evidence of tampering. We want the original. We can't find it. Can we use a copy? Yes, as long as the copy is authentic, which means it is not subject to any, or there's no evidence of any tampering. We start with the premise in the hypo that the document, that the copy is authentic. How will I know if it's not? Because the fact pattern would have to give me some evidence to show that there was some sort of tampering involved. Okay? So if we're talking about a contract, a warranty deed, obviously the copy from the courthouse, is that going to be authentic? Of course. If it's a copy I have and there's no evidence in the hypo that there was any tampering, is that okay? Yes. If I show you a warranty deed that has my Sharpie marks where I removed 2 or 3 of the warranties from the warranty deed, do I now have evidence that maybe something was tampered with? Yes. But for definitional purposes, you always assume the document is authentic, quote unquote, unless there's evidence of some sort of tampering in the first place. So, some of the questions about the best evidence rule just is the copy, is the piece of paper authentic? Can I bring it in? If it's the original, of course. If it's a copy, yes, as long as there's no evidence of any tampering. That's half of your best evidence rule questions. What is it? Does the rule apply? It doesn't apply to objects. And two, is it a copy that is now authentic? Generally it is, unless they tell you otherwise. The second kind of best evidence rule question is, they're going to ask you if the best evidence rule applies. Does the best evidence rule apply in this situation? When does it apply? In 2 different little hypos. 2 different hypos. So again, keep the first part of it separate, is just what is an authentic piece of paper and can I use a copy? That's number 1. Number 2, if the piece of paper is okay, does the best evidence rule even apply? Do I even care about whether it's authentic or not in a copy, etc., etc.? In 2 cases, the best evidence rule will apply. Number 1, when I'm trying to prove the contents of the document itself. Trying to prove the contents of the piece of paper. Again, if I'm suing you for breach of a warranty deed, you sold me a house and you gave me a warranty deed, and now I'm accusing you or alleging that 2 or 3 of the warranties have been breached. Do I need the deed to prove the contents of what it said? Yes. If we're in a wrongful termination case, you fired me from my job and I'm suing you for the breach of the employment contract. Am I trying to prove the clauses in the employment contract? Yes. So if I'm trying to prove the contents of the document itself, then do I need the original or an authentic copy? Yes, and therefore the best evidence rule will apply. Exactly. The second time where the best evidence rule will apply is when you need the document to prove what the witness is testifying about. I need the piece of paper to prove what the witness is testifying, i.e., there's no other way for me to prove what I'm testifying about unless I have the piece of paper. That's proving where I was, what happened. If there is other evidence, other supporting evidence to prove what I'm testifying about, then the best evidence rule does not apply. That's why we start with that question. When does it apply? If I need that piece of paper to prove what my testimony is all about. Example, if I am accused of murder and my alibi is that I wasn't in town at the time of the murder. Well, if I was and I have the parking ticket from the airport where it was stamped at the exact time I was leaving the airport or the parking lot, and that's the exact time the murder took place all the way across town. Well, that would prove where I was. But if I was with 20 other people, if there's pictures of me all over the place, do I need that parking receipt from the airport? No. Then the best evidence rule does not apply. But if I was traveling by myself and no one knew where I was, and the only way that I can prove that I was coming out of an airport from a totally other city at that moment that the murder allegedly took place is by that parking ticket receipt, now does the best evidence rule apply? Yes, because I need the document to prove what I'm testifying about. If there's other supporting evidence, other testimony, witnesses, other things, then the best evidence rule does not apply. If I'm trying to prove the contents of the document itself, the best evidence rule will apply. Think the warranty deed and the warranties. If I need this piece of paper to prove what I'm trying to testify about, or I'm trying to prove the contents of the document itself, then the phrase goes, the best evidence rule will apply. Again, a couple of hypos you just have to do to see what this looks like, but just break it down. If I'm doing a best evidence rule question, I'm asking myself, are they testing me on that the guy's trying to bring in a copy and whether that copy is even admissible? Then I'm talking about whether it's authentic or not, subject to any tampering. And I start with the premise that it's okay unless there's evidence of it. 2, if it's the other kind of best evidence rule question, then the question literally will say in some form, is the best evidence rule applicable? Does it even apply? And it only applies in these 2 instances, when I need the piece of paper to prove the contents of the document itself, or when I am testifying about something and I need that document to prove what I'm saying. If there's other related available evidence, I don't need the piece of paper, and therefore the best evidence rule doesn't apply. And you will ask me, John, how will I know if there's other available evidence so that I don't need that piece of paper? You guessed it, they will tell you. Exactly right. And that's why facts, so important. I need to slow down and make sure I see in that hypo which version of the story are they giving me, and then the answer will be right in front of me. So again, if they tell me the only way I could prove my alibi was that parking ticket, a receipt from a restaurant, the credit card receipt, and that proves I was at that place at that moment, and there's no other way to prove anything that I wasn't there, then the best evidence rule will apply because that's what I need that piece of paper. It's the only way I can prove what I'm saying. But if there's all kinds of other evidence to prove that testimony, the best evidence rule will not apply. Then we have this rule called the completeness rule. Completeness rule. If I am admitting a writing of a portion of the document, okay, I'm admitting evidence of one of the warranties from the warranty deed. I'm admitting page 1 of a contract, but the contract has 10 pages. If one party is admitting part of an overall writing, then can the other party require that the other part of the document, the rest of the document, comes in? Yes. To show that nothing is taken out of context, to show it's part of the whole document. That's why they call it the completeness rule. If I'm bringing in a portion of the document, can you bring in the rest of the document, the complete document, so that nothing is taken out of context? For fairness, to show that even if that's true, now we look at the other 9 pages of the contract, the other warranties in the deed, now everything makes more sense. We don't want you to take out these little snippets of a document to take something out of context. Again, will you see an answer choice talking about the completeness rule sometimes? Oh, wait a minute, I think that's a rule that could apply. that sounds like a correct answer, but I only pick that answer if the whole hypo is talking about taking in a portion of the document so that the other person wants to put in the rest. Again, that's a rule. It will look correct. And as I say all the time, there's hundreds of answer choices that quote correct legal statements. The reason why they're wrong is because they have nothing to do with the facts. That's exactly right. So I'm doing a best evidence rule. Again, number one, I'm asking myself, are they testing me on the authenticity of the copy? Two, are they asking me whether the best evidence rule will apply? Or three, once in a while, they'll talk about this completeness rule. Again, that hypo has to look very obvious all by itself. One guy is admitting a part of it. Now the other guy gets to bring in the rest of the document so that nothing is taken out of context. Each one of these hypos has to look very different. They'll all start the same because someone's trying to bring in a copy of something. But again, that's why you slow down on the facts and make sure you see which version of the story they're giving you. And if you can keep those straight and slow down, even though after a certain amount of time you've done so many questions, everything begins to look alike. And that's why reading comp is so important. Divvy up these hypos into which one are they testing me on, know what answer I'm looking for, and these are really just cookie cutter definition questions, and the facts will make them very, very easy.